Manatee County 911, what is the address of your emergency?
11327 White Rock Terrace. The house next door to me, she just came over. Her strange husband attacked her, and she says she shot him. His name is Doug Benefield.
Well, it was a rapid romance. Ashley and Doug Benefield married in 2016, only 13 days after their first meeting. From the outside, it appeared to be a fairy tale, but 4 years later, Doug was shot and killed.
Benefield, a former ballerina, faces a charge of second-degree murder for the death of her estranged husband, retired Naval Lieutenant Commander Doug Benefield.
So what we're going to see in this case is really two competing theories on what happened on the day that he was killed.
The defense claimed that Ashley was defending herself from an abusive husband.
She came in, she was quite hysterical. I didn't know who was banging on my door. Said that he attacked her and she shot him.
Prosecution says it was her last resort to get custody of their daughter.
Doug was found on the floor. He had been shot twice, and deputies said there was no evidence of a struggle or abuse, and Doug was facing away from his wife at the time of the shooting.
You've got to show that you were in reasonable fear of your life at that moment, not a compilation of all bad behavior over the years that he was mentally abusive, and that gives you the right to just gun him down while he's helping you move.
The judge has denied defendant Ashley Benefield's stand your ground defense.
And these two were in a bitter custody battle, and there were court hearings after court hearings.
She has a credibility issue. Her credibility has been attacked and compromised in various court proceedings.
And ultimately, it's going to be up to a jury to determine whether or not they believe she acted in self-defense or whether or not she murdered this victim in this case.
In September of this year, I did a 3-part series on the Black Swan murder trial, the case against Ashley Benefield. Ashley was a former ballerina who was charged in the shooting death of her estranged husband, Doug Benefield. Doug and Ashley met at a political fundraiser in 2016, and despite a 30-year age difference, they married after only 13 days. Their honeymoon phase was short-lived, as there was tension almost immediately between Ashley and Doug's teenage daughter, Eva, who was still mourning the loss of her mother, who tragically passed away only 9 months prior to her dad marrying Ashley. Ashley was a former ballerina, and Doug was a businessman. Together, they decided to form a ballet company. But the company and their marriage both seemed to fall apart before even getting a chance to really get off the ground. The pair only lived together for a few months before Ashley became pregnant in 2017. She then moved from Charleston, where the two were living together, back to her mom's house in Florida. The couple separated, and the next 3 years were spent in a tumultuous battle, full of court proceedings, attempts at reconciliation, and explosive allegations of physical abuse, stalking, and even poisoning. Ashley shot and killed Doug Benefield in her mother's home in September of 2020, claiming that the unarmed man was abusive and she feared for her life. Ashley's attorney argued that the charges against her should be thrown out based on the Stand Your Ground law, which states that a person does not have a duty to retreat, and that they may use deadly force if they reasonably believe that it's necessary to defend themselves if their life is in danger. The judge disagreed with the charges being dismissed, and Ashley Benefield's case went to trial this summer. The jury deliberated for about 7 hours before returning a verdict of guilty on the lesser charge of manslaughter. A sentencing date was set for Ashley to learn her fate, but shortly after conclusion of the trial, and just when we thought that we had reached the final curtain for this ballerina, we learned that the story isn't quite over just yet. This is 13th Juror Podcast, where we unravel complex court cases and present them as compelling stories, breaking down the details and weighing evidence from a non-legal perspective, just like jurors do. I'm your host, Brandy Churchwell, and on today's episode, we will discuss the Black Swan murder trial, the case against Ashley Benefield. On July 30th, 2024, after the jury returned a verdict finding Ashley Benefield guilty of manslaughter, a sentencing hearing was scheduled for October 22nd so that Ashley would finally learn her fate. Ashley was facing 30 years behind bars, and it didn't take long for a flurry of motions to start coming in, with all kinds of allegations and requests for a new trial. On August 3rd, Judge Stephen White received an email from a man named Adam who said that he had been trying to contact the judge for many, many months. He said that he would have come forward sooner, but he didn't realize that Ashley's trial was happening, or that Ashley had, quote, acted out on her plans, end quote. The man says in the email that he and Ashley got to know each other in 2018 and 2019, which was during the time that she was separated from Doug Benefield and living in Florida with her mother and daughter. Adam said that Ashley had expressed to him many times that she was unhappy and that she was worried that Doug would take her daughter away from her and she would be left alone and have nothing. He says that she told him that Doug would follow her in his car and that she was concerned that he would hurt her. He said that Ashley asked him to harm Doug and said that if he did it, she would be safe and that then she could be together with him. She also told Adam that she would get over $1 million in life insurance money, plus Army benefits each month if Doug was killed. Adam said that he and Ashley spoke for some months after this, and Ashley kept going on and on about having Doug killed. He said that she also admitted to him that she was doing things around the house to make it look like Doug was doing things to harm her, trying to come up with plans to plant things, or trying to find an opportunity to take his life. She also told Adam that she hated Doug's older daughter because they would fight about things, and Doug would always stick up for Eva. Adam concluded his email to the judge by saying that Ashley was very flirtatious with him and seemed desperate to maintain contact. But he didn't want to have any part of this, and he offered to turn over his Facebook chats so that the judge could see the conversations between them. Now, this sounds crazy, right? But also, based on the information that came out at trial, it also sounds like it is basically in line with some of the manipulative, diabolical actions that Ashley was accused of. The jury had already found her guilty of manslaughter at the time that this email came in. But if this turned out to be true and that evidence had been presented at trial, there's a good chance that the manslaughter conviction could have been a first-degree premeditated murder conviction. About a week after the email was sent to Judge White, the defense filed a motion for a judgment of acquittal, claiming that the state failed to meet its burden of proof beyond a reasonable doubt that Ashley did not act in self-defense, despite the jury deciding otherwise. The defense claims that the state presented no evidence to rebut Ashley's direct testimony that she acted in self-defense, and says that they also weren't able to diminish her testimony during her cross-examination. The 20-page motion recounts the evidence and the version of events that Ashley gave, and gives various case law that they say supports their motion, claiming that it is the court's duty to grant the acquittal because the state's failure to contradict what Ashley said left no room for a jury to legitimately find guilt on any charges related to this incident. The same day, the defense also filed a motion that claims evidence has come to light indicating that the verdict may be subject to legal challenge due to juror misconduct. So here's the story. During juror deliberations, there was a YouTube live stream of Verdict Watch. It's basically just a live feed where the camera is pointed at the state seal or the clock or some object in the room while the jury is deliberating. It's common in all of the trials. So while waiting on the verdict or the jury question or basically anything to happen, people can chat with each other under their YouTube usernames on the YouTube channel that they're watching this on. So one person in a Verdict Watch chat that went by the name That Hoodie Guy was posting comments that the defense said contained real-time information that could only have originated from within the jury room, which is a breach of the court's instructions, the sanctity of jury deliberations, jury sequestration, and Ashley's right to a fair trial. So, for example, That Hoodie Guy posted the comment, quote, "verdict incoming," end quote, at 10:20 p.m., which was about 10 minutes before the parties were notified that a verdict had been reached. A few minutes later, he posted the comment, quote, "per sources, 5-1 guilty with the man stuck on not guilty or manslaughter," end quote. He then said that his sister was a juror and she snuck a flip phone in and was texting him. He said that she also texted him that it was 5-1 guilty, but that they may compromise on manslaughter. 2 minutes after that comment was posted, the jury returned a verdict of manslaughter. Now, the jury isn't allowed to have any kind of cell phone during deliberations because external influences aren't allowed, and they aren't allowed to discuss confidential jury deliberations with non-jurors. A potential contraband cell phone wasn't the only alleged juror misconduct. The defense says that juror number 15 was untruthful during voir dire. Now, the potential jurors were all asked a series of questions to determine if they were suitable to sit on this jury. This included questions about domestic violence, because having experience with domestic violence in a case that involves it may cause a person to have a bias that can prevent them from deliberating fairly. On the juror questionnaire, when asked if she or a family member of her immediate family have been the victim of a crime, the defense says that she answered untruthfully by omitting that she had been the victim of a crime because her live-in boyfriend had slapped her in the face with an open hand 5 times in 2016 and was charged with battery. The following month, she had filed a petition for an injunction for protection against domestic violence against that boyfriend after he grabbed her by the hair and repeatedly hit her in the face, causing a black eye, damage to the inside of her mouth, and a swollen face. But that wasn't her only domestic violence experience. In 2003, Juror 15's ex-husband sought protection for himself and their minor child after he alleged that she was being threatening and violent, including cussing, slamming doors, threatening, and throwing things at him. The ex-husband requested that his son come and stay with him until Juror 15 could get some help. The documents say that she called her ex-husband and said that she was going to end her life, and after she attempted to do so, she was hospitalized. It also says that there was constant harassment and threats to both the ex-husband and his new wife. The following year, Juror 15's ex-husband sought another injunction for protection against her on behalf of their child after she allegedly picked the child up by the arms and slammed him against the wall. The child allegedly told the ex-husband's wife that he was scared to go home. The documents go on to say that Juror 15's boyfriend also threatened to hunt down the ex-husband and kill him. Also, later on in 2014, the juror's son was charged with felony battery against his pregnant girlfriend, and Juror 15 was the bond depositor. Because of the allegations against the jurors, both Juror 15 and whichever juror allegedly snuck in a cell phone, the defense requested that the judge have the jurors come in to be interviewed. The defense didn't stop their flurry of motions with just a request for acquittal and the juror misconduct allegations. Shortly after the verdict, they also filed a motion to disqualify Judge Stephen White from the case. Now, the motion claims that Ashley fears and believes that she will not and cannot receive a fair hearing and or sentencing because Judge White has a personal bias and prejudice against her, and in favor of the state. Now, the first part of their argument is that right before the trial started, the defense asked that Judge White voluntarily step aside. They didn't want Judge White presiding over the trial because in his ruling of the stand your ground hearing, this is what he said.
The state has proven by clear and convincing evidence that the victim's homicide was not a singular act of necessary self-defense, but was instead the culmination of a lengthy, concerted effort by the defendant to eliminate the victim from her life and the life of their child. When the defendant's efforts to enlist the assistance of law enforcement, child protective services, and the judicial system failed, she took matters into her own hands.
The defense says the judge is publicly stating here that Ashley is guilty as charged, and that there's no way for him to be able to sit and decide the issues objectively when he's already concluded that Ashley is guilty as charged. They go on to say that the judge also quashed defense subpoenas for material witnesses, improperly restricted Ashley's right of cross-examination, and refused to admit corroborating evidence of Ashley's defense by not allowing in as evidence a letter that she wrote detailing her allegations against Doug. They claim that Judge White has consistently tried to water down the impact of any of their evidence, and even accused him of forcing a verdict from the jurors by refusing to send them home for the evening and forcing them to deliberate after 9:30 p.m., which they said was more than 12 hours after the jurors' arrival to court that morning. And finally, the defense says that after the verdict was given and Ashley was found guilty, they wanted to ask the judge for Ashley to be given bail so that she could go home instead of being taken into custody. Now, obviously, that's not something that we see happen after a verdict like this, but the defense gave it a go. Mr. Taylor gave his reasons to the judge why he believed Ashley was entitled to bail, arguing the legal reasons that he thinks that it should apply here. The judge listened and then asked the prosecutor if she wanted to be heard. The prosecutor, Miss O'Donnell, said that the state objects to bond, given the potential sentence is 30 years, and they asked that the bond be denied. The judge then asked the defense if there was any rebuttal, and Mr. Taylor said no. Then the judge said that he's going to remand Ashley into custody. Now, the defense says that Judge White refused to even acknowledge the motion, let alone entertain, evaluate, and rule on it, despite Judge White listening to Mr. Taylor's arguments, then giving the state their chance, and then giving the defense an opportunity to rebut her arguments. But once Judge White said that her bond would be revoked, Mr. Taylor asked if the judge would issue a written order on the bond, at which point he said, if it's required, he certainly will. So the defense adds this to the reasons why they now want Judge White disqualified. It doesn't end there. The defense also filed yet another motion, alleging prosecutorial misconduct. The motion says that the prosecutor's improper and inflammatory remarks during closing arguments prejudiced Ashley's rights and should warrant her to a new trial. Now, this is the statement that is listed in the filing. Here's prosecutor Suzanne O'Donnell during closing statements.
May 4th, only a few days later, after she files for another injunction, Doug files for sole custody of the child. This is Ashley Benefield's biggest fear, that this man is going to get sole custody. But she's making all of these grand allegations against him that he knows are not true. There's got to be something wrong, and it's probably not safe for this child to even be with her. So he files for full custody.
The motion says that this statement was entirely false and unsupported by any evidence presented at trial, and that it was actually Ashley who filed a motion on May 4th, not Doug. The motion says that given the highly prejudicial nature of this false claim about Doug seeking sole custody, that there is a reasonable probability that it affected the outcome of the trial and contributed to the conviction. The motion also says that the prosecutors repeatedly and improperly attacked Ashley's character, calling her a manipulator at least 14 times during closing arguments, claiming that she was manipulating everyone, including the jury. They also claim that the prosecutors ridiculed Ashley's quote-unquote emotional testimony and accused her of lying without evidence, which they say is also improper and prejudicial. The prosecutors are also accused in the motion of improperly speculating about out-of-court conversations between Ashley and Doug, of making false claims about the defense expert's testimony, of making improper appeals to emotion and sympathy to the jury, improperly shifting the burden of proof to the defense, and giving a false representation of the wound path. Now, together, the defense says that this has a cumulative effect and it deprived Ashley of her fundamental right to a fair trial. The state responded to the allegations of prosecutorial misconduct in a motion. So, State Attorney Ed Brodsky addressed each allegation one by one. First, the allegation that Miss O'Donnell made false statements about Doug filing for custody. Brodsky said that this is a fact, and the state made the comment with belief that this testimony had come out at trial. If it didn't, it would be considered a fact not in evidence, and the jury instructions tell the jurors not to take anything that the attorneys say as evidence. Next, the allegations that the state attacked Ashley's character by calling her a manipulator multiple times. Now, Brodsky writes that the state never once called Ashley a manipulator or talked about her character. He argues that they only made permissible and reasonable inferences about the defendant's past behavior and her testimony, which is allowed as long as it's based on evidence. The improper speculation of out-of-court conversations was in reference to the state insinuating that Doug and Ashley were speaking at the time that they had the mutual injunction. But Brodsky says that this is also based on evidence, so it's permissible. The allegation about the state making false claims about expert testimony was also addressed. So here, Brodsky points out that the defense is actually the ones who brought this up. They said in their closing arguments, they asked the jury why someone who worked and testified for the state for so many years would now testify for the defense, implying that this fact should somehow add to Dr. Liu's credibility. So Brodsky says that invited the state's response, which is that it is common knowledge that some witnesses, especially expert witnesses, are paid for their testimony, which would be a possible answer to the defense's question. Brodsky also says that there was no improper appeal to emotion and sympathy. On the contrary, the statement that they referred to was a recitation of facts that is standard in the justifiable use of deadly force instruction. Also, the burden-shifting allegation was addressed, and Brodsky wrote that the state did not shift the burden nor misstate the law, so the comments made were permissible. And finally, the alleged false representation of the wound path. Brodsky argues that each witness indicated that the wound path was right to left and front to back, so there was no misrepresentation. I love the holidays, but with how busy they are, I'm always looking for ways to stress less. And HelloFresh helps make mealtime manageable. It saves me from searching for recipes or all the grocery shopping. I just pick my meals and everything that I need is delivered right to my door. And every HelloFresh recipe includes high-quality, sustainably sourced ingredients, like produce that comes straight fresh from the farm. There's always something for everyone to enjoy on HelloFresh's weekly menu. There's 50 chef-crafted recipes to choose from every week, plus customizable options that make your meals just the way you like them, so you'll be able to easily satisfy every craving. If you're traveling for the holidays or just too busy to cook at home, you can easily skip a week's delivery if you need to. I love HelloFresh because I always end up making things that I wouldn't have necessarily picked out, but then they become my new favorite meals. It keeps me from getting bored with the same old food over and over again. Right now, you can get 10 free meals at HelloFresh.com/freebrandy. Applied across 7 boxes, new subscribers only, and it varies by plan. That's 10 free HelloFresh meals. Just go to HelloFresh.com/freebrandy. The defense aren't the only ones who were apparently concerned with the prosecutor's behavior. A letter from a man who watched the trial online wrote a letter to the judge saying that he didn't know anyone involved, but felt obligated to send a letter to say that he felt like the prosecutors acted like high school bullies and made outright lies to the jury. He said that the details of those lies are listed in the defense's motion. Now, he also said that he believed Ashley 100% and that he was shocked to hear what he referred to as an unjust verdict. He said if you Google Ashley's name, the stories that come up about her are almost all negative. So she was convicted long before her trial ever started, and he doesn't believe that the jury was able to avoid any outside influence. He also accused the media of sensationalizing her story in pursuit of clicks and advertisers. So, look, I get it. I am all for standing up for something that you believe in. But the issue here is that this unwavering support, while noble, is not based on having all of the information. If you listen to the first 3 episodes of my Ashley Benefield coverage, you'll know that there was a ton of information that didn't come out in trial. Things that support the prosecution's theory and that go directly against the defense's theory. I didn't do my deep dive into this case until after the verdict because I didn't want to base my opinions on things that had led up to the trial. I really wanted to hear it all with a clear head and make my decisions based on what came in. Honestly, I was conflicted, but there were times when I did believe Ashley or think that she could be telling the truth. But then I did the deep dive, and my mind completely changed. I have experience with domestic violence. It was a dark, very painful time in my life. It's something that completely changed who I am as a person and the way that my brain even processes information. My instinct is always to want to believe someone when they're saying that they've also been a victim. Not believing someone when they're able to come forward is what perpetuates a cycle of silence and abuse. However, working in the true crime genre, I'm all too aware that people often claim abuse in order to avoid consequences for their actions, hoping to transform themselves in the eyes of the public and the court, shifting into the role of victim so that they can escape the label of murderer. If I'm honest with myself, my desire to believe Ashley on the stand, even when things didn't really make sense to me, could likely be from my history with domestic violence and wanting to believe others when they say that they shared that same trauma. Other concerned citizens who had also been through domestic abuse wrote to the judge. Some of them detailed their own trauma and said that their experience led them to know that Ashley was being truthful. Then there were letters sent from domestic abuse survivors that say that based on their experience, they know without a doubt that Ashley is not a victim of domestic abuse and that she was lying. Domestic violence is something that has a long-lasting psychological impact on a person. So there's no surprise that this case impacted people on both sides of the argument in such an emotional way. So all of these motions came through, and on August 20th, Judge White issued some rulings. First, he, of course, denied the motion for judgment of acquittal. He also denied the defense's motion to disqualify him as the judge, stating that the motion was legally insufficient. Now, the one defense motion that wasn't denied was the request for a new trial or to interview jurors. The state had responded to the motion for juror interviews by requesting that the judge deny it. State Attorney Ed Brodsky argued in the response that there isn't a legal basis for what the defense is asking for, and he says that the defense didn't meet the legal requirements that would warrant such a request. But Judge White set a hearing for September that would allow each side to give their arguments on why the jurors should or should not be interviewed. During the hearing, defense attorney Mr. Taylor argued that Juror 15 said in her questionnaire that she had not been the victim of a crime. But he says that simply isn't true.
Mr. Ballinger was arrested, and Miss Walcott filed a petition declaring herself to be a victim of that offense. That is in absolute and direct contradiction to the form that she signed under oath. Additionally, Your Honor, during the voir dire portion of the trial, following questions were asked.
Mr. Taylor talks very slowly. So I'm going to cut to the chase here and just give you the basis of what his argument is. So during the voir dire, Mr. Taylor says that potential jurors were asked if they had ever had any dispute with their significant other about their child or custody of their child. They were also asked if they had ever had a heated custody battle with anyone. Now, Prosecutor O'Donnell addresses some jurors that raised their hands and asked them questions about it, but there is nothing on the record of her speaking to Juror 15. Then, when it's Mr. Taylor's turn to ask the jury questions, he asks if any of them have been involved in domestic violence, if any of them know or have experienced an abusive male, and he says that the court reporter is making notes of the paddles that were raised for each of those juror numbers as he's asking these questions, and he says that Juror 15 was not one of the ones whose paddle was raised. Now, Mr. Taylor argues that Juror 15 has experience with all of these things, and although her ex-husband's petition for custody was dismissed, he said that that's irrelevant for the purposes here. Then it's Miss O'Donnell's chance to address the judge about what she says their argument is about this whole voir dire situation.
The representation that Mr. Taylor has made about what happened in jury selection with those paddles is completely and 100% inaccurate. When those questions are asked, paddles are raised. The court reporter does not write down the number of every paddle that was raised. Not once have I ever seen in a transcript that the court reporter tries to write down 30 different paddle numbers as to who raised their paddles. I cited in my motion 2 different places where I asked very specific questions, and I started asking questions in response to that. I can represent to the court that I almost never go to every single person that raises their paddle. That is a habit of mine. I don't go to every person that raises their paddle. So to make the assumption that someone did not raise their paddle based on the fact that I did not speak to them, I think is completely improper. And I also believe that the defense asking the question, has anyone had any contact with domestic violence courts? He says in his response, 2, which I'm assuming means he saw 2 people raise their paddles. Nowhere in that transcript does anyone say what numbers raised their paddles. It is quite possible that Miss Walcott did raise her paddle, and we are sitting here maligning her, acting like she withheld this information inappropriately, which I find highly objectionable.
Ms. O'Donnell goes on to ask the judge, how can we ever get jurors to come in there if they know that after the fact, someone is going to dig into every aspect of their life and call them liars when they didn't lie and distort the record to their own needs? She also says that while Juror 15 may have checked that she had not been the victim of a crime, there are very different definitions to people of the word victim, and not every person will answer these questions the same if they don't understand what is legally meant by them. Ms. O'Donnell says that if Mr. Taylor would have done his due diligence, then he could have questioned Juror 15 himself. She also says that she doesn't believe that the juror potentially being a victim of domestic violence would make her prejudiced against another woman who is saying she also was a victim of domestic violence. If anything, she says, it could make her more sympathetic. The other issue that is brought up is the live stream comments made by someone claiming to be the brother of a juror. Now, the defense had a witness ready to testify that she said that she's the one who sent the screenshots of the comments to the defense, but she ended up not testifying. The defense made the same arguments that were made in the motion that I already went over, and then the prosecutors had their chance to give their side. The first argument is that there is some discrepancy about the timing of when the comments were coming in. Relying on the time of the verdict clock isn't sufficient, since the accuracy of that can't be proven. And aside from the time discrepancies, the source is anonymous, which Ms. O'Donnell argues carries the least amount of credibility in a court. She also then explains some inconsistencies.
One of the things that is internally inconsistent is that this person is apparently saying his sister is on the jury. And his sister has a flip phone, his sister's giving information. But the comment that says, this is what she just texted me, and then he gives like a colon, per sources, 5-1 guilty. Why would a juror say per sources? A juror would just say, we're saying 5-1. They would not say per sources. That indicates to me that whoever this hoodie person is, if they are getting the information, is getting it from someone other than a juror, not someone that's on the jury, because why would someone on the jury say it like that?
The prosecution argues that there's no evidence to indicate that this was anything other than someone posting on social media to get attention. The defense contacted the channel to try to get copies of the texts and emails online to try to find out the identity of that hoodie guy, but they said that the channel was unresponsive and they were shut down pretty quickly. So the judge decided that there was sufficient evidence to grant the request for interviews, and he decided that they would be in camera as opposed to in an open courtroom in hopes that the jurors would feel more comfortable giving candid responses. So each juror was sent an order to appear, letting them know a date and time to show up to the courthouse so that they could be interviewed and answer questions related to the matters and issues set forth in the defendant's motion. So the jurors were questioned, but it wasn't televised. I did get the transcripts, though, so that we could see what was asked and what the answers were. They were first asked if they had talked about the case or the proceedings for today with anyone. Now, most of them had general conversations with friends and family about being jurors and what the trial was about, but nothing about the specifics for what was going to be covered on that day. They were also each asked if at any time during deliberations they had a cell phone or saw anyone else with one. They each said no, and some also mentioned that the deputy collected their cell phones, smartwatches, and any other electrical devices because they weren't allowed to have them during the deliberation process. Now, every juror that was asked said that there was nobody that spent an inordinate amount of time away from the other jurors, either in the other part of the jury room or the restroom. and nobody witnessed any jurors conversing outside of other jurors' presence or communicating outside of the jury. So based on these questions and answers, it seems like the whole smuggled flip phone thing didn't really check out. Now, Juror 15 was also asked about her jury questionnaire that she filled out and the voir dire process where she was asked to raise her paddle for different questions. So the question was asked by Mr. Taylor during that voir dire. Who is aware that in every county in every state across the United States, there are domestic violence courts? And she remembers raising her paddle for that. He then asked if anyone has been involved in domestic violence courts, and Juror 15 said that she did not raise her paddle. She said that the reason that she didn't is because both of the injunctions that were filed were dismissed. So she thought that the question about being involved in the court wouldn't have included her. As far as the juror questionnaire, Juror 15 was asked about circling in for no on the question that asked if you or an immediate family member has been the victim of a crime. She said that she didn't associate the vague question about being a victim of a crime to domestic violence. She said she's never been shot or sexually assaulted or anything like that. So when she read that question, that's where her mind went when she thought about being the victim. She said it didn't even occur to her that domestic violence would be included in that question. Now, as far as the custody dispute, Juror 15 said that the two cases were dismissed, so she also didn't consider herself having been involved in any contentious custody battles. Now, this was clarified. So there was a custody agreement in place when she got divorced. And when her ex-husband got remarried, she said that the new wife began this whole custody thing, wanting to have her son with them at all the time. Now, they lost and it was dismissed, so there was no other issue. They never went to court, never argued about who was going to have custody or share custody or anything like that, and nobody filed motions to modify the original custody agreement. So she said that she didn't consider herself a part of what that question was asking either. I love when I'm able to get someone a gift that they wouldn't necessarily get for themselves. That little bit of luxury that they don't even know that they're missing. For quality gifts at an affordable price, my go-to is Quince. Quince lets you treat your loved ones and yourself to everyday luxury at an affordable price. Something that everyone needs in their closet, in my opinion, is Quince's iconic Mongolian cashmere sweaters, and they start at only $50. Or for the ultimate year-round gifts, check out their 14-karat gold jewelry. They have Italian leather handbags and European linen sheet sets as well. Whatever you're looking for, all Quince items are priced 50 to 80% less than similar brands. So how do they do that? By partnering directly with top factories and cutting out the cost of the middleman, which passes the savings on to you. Quince is on the nice list. They only work with factories that use safe, ethical, and responsible manufacturing practices. And they use premium fabrics and finishes for that luxury feel in every piece. I personally love their aviator lenses, and they're way less expensive than the ones that I priced from similar brands. I ended up buying a pair for myself, and I got some for some family members as well. I love them. Gift luxury this holiday season without the luxury price tag. Go to quince.com/brandy for 365-day returns plus free shipping on your order. That's QUINCE.com/brandy to get free shipping and 365-day returns. Quince.com/brandy. So Judge White decided that there's no reason to have a new trial based on juror misconduct because there's no basis that shows that there was any juror misconduct. But you know what? Kudos to the judge for getting to the bottom of it. It's important to protect a defendant's right to a fair trial, and asking those questions to make sure that things were done properly, that was a big decision, and it was the right decision. So the verdict stands, and the sentencing date was held last week. Now, Doug's family sat in the gallery and watched as Ashley was brought in with her hands cuffed in front of her, wearing a navy blue Department of Corrections jumpsuit. She took a seat with her attorney and the proceedings began. Ashley and her attorney are actually seeking what's called a downward departure or downward motion. This means that the defense is basically asking for the judge to give a lesser sentence than the minimum required by law for a felony offense. This isn't something that's commonly done, but if there are mitigating circumstances, then the law allows for a judge to make that decision. Some examples of those circumstances that allow for the judge to give a lesser sentence would be if the victim provoked the defendant into committing the crime or initiated it, or if the defendant was under another person's domination or extreme duress during the commission of the crime. Now, since Ashley said that this was self-defense and she says that she shot Doug because he was going to attack her, the defense can argue to the judge that some of these mitigating circumstances apply and see if he's willing to approve their request. Now, Judge White explains as the hearing begins that the evidentiary burden for this is on the defense. They have to prove first that she qualifies for the downward departure, and then they have to prove that it is the most appropriate sentencing option and that the court should exercise its discretion to do so. So, since the burden is on the defense for this, they are the first to call any of their witnesses to give relevant testimony. They call to the stand mental health professional Dr. Barbara Russell. Now, Dr. Russell did one phone interview with Doug. And based on that interview and documents that she said she read, she apparently diagnosed Doug. Dr. Russell says that Doug exhibited criteria that met the diagnostic categories for narcissistic and antisocial personality disorder. She said that Doug had little to no empathy and that he felt entitled to the admiration of other people, whether or not he deserved it. She says that that can contribute to abuse. Now, as far as Ashley, she says that Ashley is suffering from PTSD caused by complex trauma that is rooted in the abuse that she suffered in her marriage to Doug. She says at the time of the incident, Ashley was in full survival mode and was under severe duress. Now, during cross-examination, the prosecutor asked Dr. Russell about Ashley's diagnosis of histrionic personality disorder, which basically means a person is very melodramatic to gain attention. Dr. Russell says that she is familiar with this diagnosis, but claims that it is a false diagnosis, and says that women who have been victimized by abusers are often given this diagnosis if the person who is seeing them doesn't understand the full scope of what's happening in their life. Now, what's interesting here is that the prosecutor, Miss O'Donnell, brings into question Dr. Russell's ability to testify in an objective, non-biased way. And there are a few reasons for this. First of all, several weeks after Ashley killed Doug Benefield, she actually moved in with Dr. Russell. She lived in the home with Dr. Russell and Dr. Russell's husband and child for a total of about 8 months. Also, during the trial, there was a small group of people protesting outside the courthouse with signs that said, "I stand with Ashley" or "Free Ashley." Now, this included Ashley's mom and even her and Doug's young daughter. And also, apparently included Dr. Russell.
You know about the demonstrators that were out in front of the courthouse on numerous occasions during this case, correct?
Yes.
Holding signs, Free Ashley.
Yes, that's the Community Defense Committee called We Stand with Ashley.
Okay.
I'm familiar with that.
On numerous occasions, you were also out there holding signs.
Yes.
And marching with this group.
Yes.
Okay. And you still consider yourself unbiased?
Absolutely. It's part of my ethical obligation as a licensed clinical social worker to be involved in situations that involve injustice.
Dr. Russell is the only witness that the defense called, so when her testimony wrapped up, the prosecution had members of Doug's family come up to give their victim impact statements. Now, victim impact statements are one of the most difficult parts of a trial for me to watch, but they're also one of the most important. The trial process itself is so structured, and the legalities and formality of everything can often make it seem somewhat sterile and impersonal. The victim impact statements are the opposite. They are personal narratives often rooted in raw emotion. The person giving their statement isn't confined in the way that the attorneys and witnesses are during a trial. And giving them the chance to express to the court their feelings may be cathartic for them, while also giving the judge better insight into the impact of what happened, far beyond what evidence and case files can express. Doug's brother, Dave Benefield, was up first. He recounted getting a call from his teenage niece, Eva, saying that she was worried about Doug because it wasn't like him to not answer her. Dave says it wasn't long after that he got the call that his brother was dead. When he called Eva back, before he could even tell her what happened, Eva said, "She killed him, didn't she?" Dave describes the struggles that he and the family went through following Doug's death. He describes sobbing, wailing, and gasping for air after having to see Doug's body. Ashley sits, barely moving, looking forward and down while Dave speaks. Dave gives some fond memories of Doug, little quirks that still make him smile fondly when he thinks of them. Then he addressed Ashley and the defense.
The defense presented a slander campaign based upon gross exaggerations of Doug's own testimony and unverified allegations from Ashley. Doug patiently endured Ashley's verbal, emotional, and legal abuse for over 3 years and was still willing to reconcile with her, even serving her up until the time of his death. I found out after his death that there were many people who strongly encouraged him to leave you, even some who expressed concern for his life, but he would not give up on you.
Dave told Ashley that she caused him the greatest grief that he has ever known, but he says he forgives her and prays for her healing and God's grace over Emerson as she grows. Wes Benefield, another brother of Doug's, spoke next.
I asked the court to give Ashley Benefield the longest possible sentence for the egregious cold-blooded murder of her brother Douglas Glass Benefield. Doug has always been a man of faith, loved his family, loved this country, and his friends.
Wes said that Eva lost her mother and now no longer has a father. He said Ashley treated Eva terribly, treated Doug terribly, and says that she killed him in cold blood. There was an objection from the defense. They said that the victim impact statement doesn't include attacking Ashley. So Wes then finished his statement by giving his fond memories of Doug and explaining the loss that their family now has to endure because of Ashley's actions. And he asked for the maximum sentence possible. Tommy Benefield, Doug's cousin, is up next. He tells the judge that they heard from the mental health doctor who says that she spent 90 minutes talking to Doug. But he says that he spent 59 years with Doug. So they knew him much better than any 90-minute expert. He talks about Doug's impressive military career, his happy marriage to Renee, and the life that he lived serving his country and his family. Tommy talked about the legacy that Doug left, including patents that he has that are used all over the world now. Tommy says that Doug was stolen from their family, from his children, and from the world, and they ask for Ashley's sentence to reflect that. The final victim impact statement is from Eva, Doug's daughter. She walks up to the podium in a brown plaid blazer. There's a patch in the shape of a red heart stitched on the back right side of her jacket, and one on the left front, right below her heart. These red hearts are stitched in the exact places where her father was shot. Eva explains how her dad sent a text every morning as soon as she woke up, and when she didn't hear from him that day, she began blowing up his phone and even Googling traffic accidents in the area. Eva then addresses Ashley.
Ashley, since the day you shot my father, I have only had one question to ask you. Why? Why did you end my dad's life knowing he was my only living parent and the only person I could confide in, and count on for everything I needed as I turned into a young adult? Why did you willingly take away your daughter's father, knowing the consequences of your actions would leave her without either parent to help her navigate through her own life? You somehow managed to orphan not one, but 2 young girls. Unlike Emerson, I am fortunate enough to have known my dad for a full 19 years before you ended his life. He taught me how to paint. He attended every extracurricular activity I had. He took me to dinner on Valentine's Day. He drove almost an hour out of his way every day to drop coffee off in the school office for me and my friends. When he was in too much pain to surf with me, he would sit under an umbrella on the beach all day during the hottest months of the year. He would cut fresh flowers from the garden every morning before my mom woke up and left them on her bedside table. While I ran in the mornings before school, he cooked breakfast so it would be ready on the table when I got home. Every Saturday, We made oatmeal cookies together. Every Sunday, we would go to church and get a coffee after. When you moved into my childhood home, I watched my dad fix the door frame with a crack in it from where the neighbor had to knock the door down to get into the house after my mom died. I watched my dad paint over every memory in every corner of that house, change the furniture, rid the house of every bit of my mom that was left so you could enjoy life without remnants of my dad's late wife and soulmate. I had to come home from school to see you barely clothed, sitting on the countertops my mom used to cook our family dinner on. I had to live in a house stripped of memories I still cling to so I can remember the happy childhood my parents gave me. Not only did you make my home nothing more than a house with 4 empty walls and a roof while I was grieving the loss of my mother, you tried to bring my mother's sweet spirit into your soulless world by spreading lies that she was killed by my own dad. You got medical records pulled, and you were moments away from getting her removed from her own grave.
Apologize for interrupting. Same objection.
The defense objects again, not wanting Eva to be able to address Ashley or the things that she did in this way. It's sustained, and then Eva continues.
When you left my dad the first time, I watched his face as he read the letter you left on the bed for him. The house was quiet that day, and while I felt sorry for my dad because I saw the pain in his eyes, I was secretly excited to have my dad back. Those few months that he received nothing but radio silence from you, I was able to finally regain the relationship we once had. Things finally felt normal again. Easter weekend of 2018, my dad insisted that I drove to Florida with him so I could enjoy Easter Sunday with my half-sister. The night before Easter, you and Alicia pulled me aside before dinner to try and convince me that my dad was a monster, that he killed my mother, that he was evil and I was unsafe. The next morning before you brought Emerson over to open Easter baskets, my dad could tell something was off.
Once again, the defense objected to stop Eva from being able to read her statement.
While I feel deeply sorry for everyone who was affected by these last few hurricanes this year, they couldn't help but remind me of the time my dad drove 8 hours through a hurricane to come help you board the house you lived in at the time. My dad was the opposite of what you have attempted to portray him as. Doug Benefield was kind to a fault. He was smart, he was strong, and most importantly, he was generous. His generosity is what got him killed. December 2nd, 2014, 10 years ago yesterday, my dad was out of town when I found my mother dead on the floor at 14 years old. Her funeral was the first and only time I saw my dad cry. Not even a year later, he met you during what I imagined to be a very lonely part of his life. You decided to put on your biggest act of your career and pretend to be everything he needed to fill a void. I watched him.
Again, an objection. This has now happened multiple times with all of the family members, and the judge and the prosecutor have the following exchange over it.
I'm pretty sure I confirmed before we started that the state had gone over with its witnesses the nature and extent of an appropriate victim impact.
I just have a difference of opinion as to what they're allowed to say, Judge. So it's difficult.
I'm going by the Florida law.
For death penalty cases.
And I said that it's appropriate. I think they're good guidelines.
So the guidelines that the judge is using is for death penalty cases. And obviously this is manslaughter. This is not a death penalty case. I think it would be better to go by the law of the kind of case it actually is, but I'm not a Florida judge. Eva wraps up her statement.
I watched him bend over backwards for your every need. For years, he gave you everything he had, time and time again, trying to show you, Emerson and Alicia, nothing but love. He wanted nothing more to show you what true acts of love are. You took advantage of his willingness to give, and he gave you his life. After my dad passed, there were a lot of sleepless nights contemplating if my life was even worth living. I had no financial help, no parental guidance, and no will to live. The idea of ending my own life was oddly gave me some sort of satisfaction knowing you would have to live the rest of yours with blood of 2 Benefields on your hands. Shortly after those dark days, I realized I would selfishly be doing my parents a disgrace to not live every day to its fullest as they had taught me before they passed. I also realized that not only would you not care if I was dead, it would probably be beneficial to you. I'm the only one who can speak truthfully on behalf of my father and fight for his justice. While the grief of my parents will always live within me, what hurts me the most is not the thought of not having my dad anymore, because I will always have him around in spirit as I continue to implement the lessons he taught me during my adult years. What breaks my heart the most is thinking about how he found you at such a vulnerable part of his life, gave you everything you asked for. After you shot him while he was unarmed, he laid there bleeding out, unable to speak or to breathe. completely helpless and dying alone.
The defense then did their closing arguments to basically go back over all of the evidence that they already went through in the trial. Mr. Taylor made his arguments for why he thinks that Ashley should be given a lesser sentence and also went over everything again that he says proves that Doug Benefield was basically at fault for everything. The state gives their closing, which again is much of the evidence that we've already heard. After hearing everything, Judge White was ready to make his ruling, starting with the downward departure. Judge White acknowledges that whatever lens you look at this case through is going to affect how you view the players, the results, and the people involved, as well as the outcome. Those who believe the prosecution's theory will obviously want a different outcome than those who believed the defense's theory. The defense's lens involved Doug being the aggressor, the provoker of the incident, and they wanted Ashley to get a lesser sentence because of it. Judge White, however, denied the downward departure. He then issued his sentence. Ashley Benefield is to serve 20 years in Florida State Prison for the death of Doug Benefield, followed by 10 years of probation. Because of Dr. Russell's testimony about her PTSD, Ashley is required within 60 days of starting probation to have a mental health evaluation and complete any recommended treatment that comes with that. Now, she also must forfeit the gun that she used to kill Doug, and she will be required to pay restitution. On the courthouse steps, in front of dozens of cameras, Tommy and Eva Benefield gave their final thoughts on the sentence. Tommy said that he understands that Ashley was convicted of manslaughter and not murder, so he was satisfied with the 20-year term. He also said that he knows Ashley's attorneys are going to appeal this, and he says that his family and the prosecutors will fight very hard to keep Ashley behind bars for the appeals process. Eva said that her dad was the best man she had ever known, and she's waited a long time to be able to confront Ashley and address her face to face. So she was thankful for the opportunity to do that today, and she said that she hopes prison serves her well. It's been a long road for the Benefield family. The trial, the verdict, and the sentencing were big steps in this journey for them. And with that behind them, they are able to enter a new chapter of trying to heal. They're realistic in what's to come, though. They understand the appeals process, and they know that their fight for justice for Doug isn't over. As of now, they have no rights to or communication with Emerson, though they hope to change that in time. Tommy was not happy seeing Emerson picketing around the courthouse with Ashley's mom. He said there are a lot of people who see that as child abuse, and he says that the state needs to look into that. But in the meantime, the family is able to feel a sense of peace with this chapter behind them. And they find comfort in their belief that Doug is now reunited in eternity with his true love, Eva's mom, Renee. If you're enjoying 13th Juror Podcast, please leave us a review on Apple and Spotify, and share this episode with your friends. For more information, photos, and episode guides, visit 13thjurorpodcast.com.